No si abo pe ma de mama ye mamu nyina adwo e mama kwaba eba United Television so ye ka se boy saka fi o maimu na fa mahudo bi so ene aso ne so de asum don hwe bakwa dan nim ne ye kam specialized insuo this way chocolate drink and then the coffee drink best point service salons best assurance you to nchini need fufu any tabakwa nyina kan bi ena ka se boy mo so asene a ye de brem na de bedi mu akotini bi ene se ene Supreme Court nsam a mampende da mahama kwa no empanimfo aboagu
Supreme Court in Semna Emo NDC lawyer Chachuchi Kata were filing applications for mienu.
Na omenso afọ no no hwe akwantepon nsam so amampene sayin so to na djuma so e de atojo echiru se akwantata for ye kwan no enye omu nyina na etu omoka.
Lawyer Dominic Aini edi akotene e wo NDC petition no emo wo say ensema ene Supreme Court ebuaye no wo mu amua ni yie wati kra.
We are some man saying na pumdi aso de atojo echiru se kasa de COVID-19 ro no ombetumi e de ababibi memu ha.
Kongo fu hu asem o subonto bi a wo mo ete so e wotade no eso no aka muntum ama enipa bebre na afem ahwe wo mo enkwa
ensem bi eka we no ho ne ade bra mo se kasebo e wo UTV so akenkanfo eso mo enne anwumre yeme Agya Kwabena mene
Obahima Afia Asiedu
Afia kasebo no emu nsem nie ye nyina nim se ma mpani dada mahama e de nsema bi akodan Supreme Court mpani for se nhwe nkan fipinu ne adunaba ye to ogidi se ne ma bi anhyeda enkoyie na nsem no mu di kan ebu abako de to so mienu ene se ne nsem ode koye ne se Supreme Court mpani for ba ma kwan a wonsan emie asem no mu ebio nene abedwafo kwa asetena no mpanyifo makomako enson a ye ajagefo no kire se nsem mo de bae no nso bi anim entuma boagu.
The petitioner in his submissions made reference to Section 26 of the Evidence Act 1972 NRCD 75 NRCD 323, which he says operates as a stopper against the first respondent for failing or refusing to call a witness as contemplated by the filing of a witness statement. We wish to state emphatically that Section 26 of the Evidence Act, which is on conclusive presumptions, is not applicable in this case in view of Order 38 3E5, Sub 5. The rules permit a party to call or not to call a witness who has filed a witness statement to testify, as the mere filing of a witness statement does not constitute an election to testify, as we rightly held in our ruling on the 11th of February 2021. Again, the petitioner did not decide to close his case after the testimony of his third witness just because the chairperson of the first respondent had filed a witness statement. This is because in law, a plaintiff or petitioner does not require evidence from his or her adversary in an adversarial system as ours to prove his or her case. For the above stated reasons, we find no merit whatsoever in the petitioner's application to reopen his case for the sole purpose of compelling his adversary's intended witness to testify through a subpoena without indicating the sort of evidence he intends to solicit from the said witness and how that evidence is going to help the court in resolving the dispute before us. We accordingly refuse the application and proceed without any hesitation to dismiss him.
Yedaswa e wo Supreme Court nsem na emuna ababeto dwase lawyer panyina wodi akotene ema NDC for e wo nsem no emu lawyer Chachuchi Kata sabra ye ka say they was not filing applications afofo mienu a ode akwakodan court no.
I have to say, my lord, that we are struck by the fact that Section 72 of the Evidence Decree or the Evidence Act is not referred to, but Black's Law Dictionary is referred to. But in any case, my lords, I wish to notify your lordships that we have filed this morning, just this in the last half hour. So we have filed an application for review of your ruling of 11th February. And in connection with that, we are also filing an application for stay of proceedings pending the hearing of that review application. And no doubt the next steps in this case will be dependent on those applications.
Empenifo mampeni na nado eyi omuse omeboa no femu omanyi asoafo ni bi eyo man soafo hwe akwantempon samso na Veti Committee okomanim na bedwafo bi sane sanye bi a akontratafo ye ka akwan o magana mu wo mo amaye o mu de nyina wi no aso o man na timi eti o mu nyina ka na ne se mo kan se da bi yentimi nti o mu nyina ka na mu no wo mo ye mo fam de bi betumi se na be yo betumi eti o mo ka
Honourable Minister for Roads, Ghanaian road contractors are very, very unhappy. When will you pay road contractors?
It's not in the interest of government, it's not in the interest of this country even to delay payment because of the huge interest that delay payment accrues. Mr. Chairman, contractors contractually are supposed to be paid within 90 days from the day a certificate is raised. And great effort had been made from time to time to pay contractors. And Mr. Chairman, we have been very, very fair in paying contractors. We do not discriminate when it comes to payment. And in the case of road fund, it's controlled by a board, under a strong leadership. I can assure this committee. Yes, there are also outstanding payments, and efforts are being made as and when monies are released to the ministry. But, Mr. Chairman, we must also not lose sight of the facts of the difficulties that we all went through as a government and as a nation. Resources of the nation in terms of revenue went down. So it also impacted negatively on our payment regime. But we are hoping that this trend will change and contractors will see an improvement.
Kane Attorney General Obediachi Dominic Ayine na eba to Supreme Court nsemi a ekoso e honso a odi akotene e wo NDC lawyer for no emom ninsema wodi to dwane se no kwasem ensem om de kodan Supreme Court a enne na wo hwe kwan se nka court ne bebua amwasa bie wo nsem ne bio na ekowi ase ombotugu ye no eno kire se na se atemuafo no abomutimu podada se asem no ekwan bia so ombedi e de etia omampanyin dada John Dramani Mahama na se eye sanso a omati entwa yi kra.
The Supreme Court gave a ruling in respect of our motion to reopen the petitioner's case. You will recall that that motion was filed a few days ago with a view to having the opportunity to reopen our case and have the chairperson of the Electoral Commission, Mrs. Jean Adukwe-Mensah, testify. And in our case, we wanted her to come in and testify as an adverse witness. Now, that is allowed under the rules, specifically Section 72 of the Evidence Act, allows a party whose interest is adverse to another party to call that party and treat that party as a hostile witness. Now, the strategy that we had adopted was basically to serve a subpoena on her, because as you recall, she had decided that she was not going to give testimony even after filing a witness statement. And we decided that we were going to call her by compelling her through a subpoena that would have been issued through the court system and served on her. But today, the Supreme Court gave a decision in which it basically said that Mrs. Jane Adukwe-Mensah will not be compelled, to testify. In our view, the court was wrong. In our view, the reasons of the court were based upon wrong legal premises. But the Supreme Court is the final decision maker when it comes to the law. And we have no reason not. We are bound by what it has said, this morning. We cannot depart, from it. But lead counsel for the petitioner has indicated that he is filing an application for review with respect to the earlier decision rendered on the 11th of February relating to their decision with respect to the compellability of the witness testimony of the Electoral Commission.
ye call Lotto same na mane boy nsaka che say National Lotteries Authority ene wo mu a etwa Lotto ankronko etwa Lotto na kemese metim wase asoro mu anyasem kuma kra mere bi o ye Licensing Act 844 na NL mpanyfo che say ibinum abuom na aguso ena mo ye adwuma wo mbra emra makwan na so bi so che say nye nokore emu ba ko eya Alpha Lotto Limited a ene de o ma ye santrofo hyiemu adafa de ekoso no eho
May 2019, there was an advert from the National Lottery Authority requesting lotto companies to apply for consideration for licensing to operate and pay licensing fees to the NLA as a way to widen the revenue bracket of the NLA to fulfill its obligations to its own operations and to government. Members of the Ghana Lotto Operators Association who were interested accepted and paid the requisite licensing fees to be considered. Under the license, we are required to use POS devices, point of sale devices, handheld small machines, which you use to show the lottery. This is the license. And see under whose signature is there.
License biano ya obebi a obetimi a operate akoka. Or a legal entity recognized by us. But the operations be illegal. That's one thing he has to understand. Yama license. Okay, open so moving from radio to TV. We hear another license for the television. It's a simple understanding. And the agreement, a woman clearly, of course, scope of agreement. I stated clearly say open say who operate one cancer with new games apart from NLA VAC face all game now. And say o try to NLA. Now you go into agreement with new terms and conditions for each of the game our person will introduce onto the market. Alpha has not done that. The games were running from Monday to Sunday. One submit any of them to NLA for approval, for even terms and conditions to cover it.
Director Emma Health Promotion Ghana Health Service Dr. Abwajida Costa or the ato asofo imam for Afia Metropolitan Municipal District Chief Executives and assemblymen Emma and memma ni mpanyimfo mu kan bia ewoma wo dan mekwa kese ne nketwa no Ghana enim se wo madaroma woni wokuoma enkasa COVID-19 ho enti abiding hihye bia ba wonhye so betimi edisu sade be ya entete mpotamu ahoro
Baby ayedru no yebesre yen ahemfo ewo all levels ese semri pa na yede yehia omoso omode omo beje COVID-19 education nemu omo educate omo subjects no on the preventive etiquette say omo nhye mass no yen assemblymen yen MMDAs ane DCs yesremo samre na yese mo step up education various localities and as various communities na muma make sure say yen subjects no ya manfo etiase ni ntia so mo share face mask various NGOs ne CEOs afi na yese house to house education no ye shemu kena na ye shemu den COVID-19 public education no a collective effort and sorry pastors and archbishops reverends yesremo semo ya sorry mon first message enye COVID-19 education na mon kasa so mon serve as examples for others to follow na mo obviously mon disseminate COVID-19 preventive etiquettes no yen imam for yesremo moso mo ye asoria COVID-19 education no monfa no so enka ho yen ayewo Ghana Health Service health promotion there sese yen namdwom ene lorry parks ye maame mu ewo dwom ye educate omo ye make sure say omo ton ade no omo mfa yare enkofie nti menkola no na miankasa from the last 3 weeks no ye nam dwom na ye educate omo ye GPRT for lorry parks ye set up this education so the various hotspots and ye educate omo say summary Ghana ni bia hu say ye nnuane no good nutrients ewom vitamins bi te say ye nkontomre good ye yasantoa oba ye fruit so ye anka ye popo yesremu a collective effort in ebema Ghana nyina edinkunim ewo yare ne so
yebesa echi ni akọ Supreme Court so ensennie no emu na mampani na nadodan kwakufo ado wono so lawyer kasa e obra Supreme Court mpanyifo si gina no echi na omo sam omo kan nyina ne se kamia se a lawyer fo a omo kasa de mampani da mahama no se bia asem koba na se bu asem no wi a wokwa mo ba bonte omo kasa no omo eya mo tan bi aba be share Ghana fo minimu ade afasa ajaji fo hu no kire se enya de a ehye nkran nsam yi owura kodwo opon ene de tudwa.
This is the Supreme Court of the Republic of Ghana, a bench of 7 justices. And I think on about 2 occasions, 2 others have come to join them to review some of the applications before them. Except for the application for leave to amend the original petition, it is true that all the applications that have come before this court have fallen flat. But how can it be that the petitioners' communication team now argues that the 7 justices or the 9 justices are always wrong in law and only Mr. Chachuchikata is the one who understands the law, knows the law, and is therefore always right? It cannot be. The last time they won some arguments that some of their paragraphs of Mr. Rojo Metununu's witness statement should not be struck out. You heard them right before you that it was a monumental victory. Are those not the words that they used? And we keep making the point that it is not fair to the judicial system, it's not fair to our democracy, it's not fair to the people of Ghana that when you lose an application because it is not grounded in law, or because you have failed to meet the legal standards, then you come here and literally poison the minds of the public and make claims that they may be having a predetermined agenda. That's scandalous of the courts. It's scandalous of the courts. When you make a legal argument and it is upheld, that one is good. When you make an argument and it doesn't meet the threshold, then it means that they are wrong in law or that they have a predetermined agenda. The Supreme Court has not reduced the petition to a single issue.
Ekua any National Coalition for Proper Human Sexual Rights and Family Values womo ede ato aban ene mpanyimfo enim so omanya ntie se ememma ne memma womo eda gay enna emma ne ma womo so ededa lesbians afi bisexual form a obu a ne ma da san ne memma eda transgender ono no yo ba opese yesisa ne ho eye ne bema pese yesisa yo ba ene womo a yaka mo ho abom fam ho kuye intersex rights for no oma bie office bi otesa no e won kran ha na Ghana for bi ne sinya mienim we di asefim entwa yie krakrakrakra se no kre se office no e wo ha mpanyimfo nhwe na ontum UTV yen cameras kwa pro ye ne omanfo bi etwetwe nkomo.
The society is your culture. Obeka human rights as but utikroma where your rights ends is where somebody's nose begins. Enti the first say eye obi human rights no eye enye Ghana eye culture no yentimi ntina ma be ma ne be ma nware ewo Africa ha me enso so me first say yen cancel yen twehwe office no mo se bia otesa no ha no yen kwehwe office no na yen chinkrofu kro no yen tu office nim Ghana ye omra wo
intia wo Quran say wo a wo muslim ni bia eye chiwade edima o say sabi wo be fa wo yere ewo ni tu babia wo kọ babi so wo obeye sane twede amfonyame se ewiase nhira afre wo so atemudan so yede wo be kọ ejam adise wo nyante sane ma ne dia aban edi bai a om office dia enanka minko ade misre esre kotodwe kase se wo mo pese nume eba beto yeso dia ene sa office ndia yen close
na Ghana bebi a yɛti nyankopɔn ahyerɛ pi yɛwɔ asomdue yɛwɔ bibia ɛsɛsɛ ekuro epebia nyankopɔn de amɛ na adɛnti na ɛbɛtwɛn sɛ nkurɔfoɔ yi ɛde emusio bɛyɛ man nti mesrɛ yɛsan frɛ government ana yɛ mampanyi nyankopɔn wɔnhyɛ no pi na sa office yi a yɛbɛbie wɔ Ghana ha yɛntu mɛ ɛfrɛ sɛ Islam emra etia so ɛna Kristo nso menji ndi sɛ ɔmo nso ɔmo pino ho bisa
de betumi aka ne sɛ enye kwan asɛsɛ yɛ fa so ɛde ebu yɛ man enye ebrɛ nneɛma bebree ase enti no me de enke betumi a ɔmo nkrosu na yɛ mpɛsa we ne wɔ yɛ man mu ende yɛ culture na emmobra
anka bani hwe no nkrosu kra wo hia kra ska gie ne a wo sabi ebi ma nyinyi nti no mpa no mo yɛ bata sɛ simisi sa because kro no yɛ wo nkwala from oba sɛ ko school yare so aba nyama bebrebe na asa ban atwi sankra na ɔmo enko adadem Ghana yɛ culture kyerɛ sa yɛ culture kyerɛ sa yɛ san obefa ba na ba fa ba na no yɛ dislike kra ani yɛ culture de nka sɛ kra ma sɛ Ghana emema ne endorse Emma bebre na yesi ya de we a o sha ebi metu aware
Also mo friend wudi mutwa ne che one friend
LGBT o se bibisa
queer
LGBTQI queer intersex rights for ba omudi ni do so
won fa mo queer nkom ba bi ne so yen fa yen intran ya Ghana pesa nyama ne manu kra mo fa mo queer nko ya home so aba ebe to akase bo no so